This is Dale Buckner's Financial Clinic. Securities are offered through United Planners Financial Services, member FINRA, SIPC. Dale Buckner, Inc. is a registered investment advisory firm. Dale Buckner, Inc. and United Planners are not affiliated. This is Dale Buckner's Financial Clinic, visiting with Adair Buckner, and we are related. We're married, so as we kind of go through this process, Adair is an attorney, and you tell us a little bit about your practice. It's kind of changed a little bit in recent years, and I'm kind of really glad we get to work together more this way.
Yeah. Most of my practice now is in estate planning and probate and kind of business related matters like incorporation and running a business. Still doing a little bit of employment law, but only from an office practice standpoint. Helping people with employee handbooks and resolving matters that come up and staying away from the courtroom, fortunately, these days. Been there, done that, and I'm doing a kinder and gentler law practice now. I like it much better.
A lot of the areas of a certified financial planner practitioner and an estate attorney kind of overlap a little bit, and it's very good that I always want to say that you have a team that's working for you, and one of your team members should be a person that is an attorney that works primarily in the estate planning. And then certified financial planner is also there that has been trained in estate planning. So you kind of get two bangs for your buck.
Well, and a CPA is usually a good person to have in the mix too.
Absolutely. A enrolled agent or a CPA is a very good person. When we start talking about taxes, there's always those little nitpicky little things that the IRS throws in. I think they've got, 8,000 pages of tax law that you have to go through.
I have no idea, but at least from an estate planning standpoint, it's not nearly as bad as it used to be. As long as the estate tax exemptions stay at $12.5 million per person, that's not nearly as big a consideration as it used to be. In fact, that's really completely changed the estate planning legal field over the last 10 years. It progressively has increased and increased and increased. Fortunately, I didn't like to deal with all of those crazy issues of trying to delay estate taxes, but it's rarely a consideration anymore.
As we go through this is a 2-part series that we're going to do, and if you listen to both parts, you're going to have a really solid understanding of how your stuff and your wealth, your assets that you have, virtually all of the things that you call your things can go to your heirs exactly the way you would wish them to go to your heirs, and you likely go to them as income tax efficient and if not income tax free as possible. So as we kind of go through this, the first part that we're going to be working on, if you're going to be listening to this one, is we're going to be working on the basic estate plan, which is wills, powers of attorney, directive to physicians, and medical powers of attorney, and a few other little things that may make your estate go appropriately to your heirs. And I kind of want to start it off just for the basic folks. What is a will, and why would a person wish to have one?
Well, a will, of course, is the legal instrument by which a person makes provision for how their estate passes on their death and who will be in charge of making sure that happens, or the executor. And in a will, you can also set up what's called a testamentary trust, which wouldn't come into play until you die. And that's opposed to a living trust, which you set up and becomes effective during your life. But if there's a testamentary trust, then there's a trustee appointed in the will also, and that's real common for minor beneficiaries, or they don't have to necessarily be minors. Most of my clients would prefer to see trust remain in effect until the beneficiary is at least 21 or 25 or 35, or whenever they think the beneficiary might have a brain in their head. Otherwise, if you don't do that, then your beneficiaries are entitled to their inheritance at age 18. And if they're minors at the time of your death, then there has to be a guardianship established if both parents are deceased, to take those assets and administer them until the child turns 18.
So, kind of give me a rundown on how difficult the guardianship can be.
My prime example is a client I have whose uh, daughter was 2 years old when he was killed in a car wreck, and his grandmother helped administer his estate. Fortunately, she had the wherewithal to do that, but we had to set up a guardianship for this 2 year old, and it was a large estate, so it was fairly complicated. We had to have a corporate manager of the funds appointed, and they had to file yearly accountings for every year until the child turned 18. And then an ad litem, attorney ad litem, is appointed to represent the interests of the child. And near the completion of the 18 year, the child's turning 18, the attorney ad litem decided that he or she wanted to have an accounting for everything that had happened during the term of the guardianship, and tried to question some of the actions of the guardian. And it was really just a very painful and distasteful thing. And I mean, even under the best of circumstances, there's a lot of paperwork and yearly accountings and a lot of red tape that has to be gone through every time you want to sell or buy assets for the ward is what the child is called, the beneficiary. So it's very expensive, cumbersome, and a pain in the neck.
So, we would wish you, as a listener, to avoid guardianships whenever possible. They
Yes.
sound like they would be very helpful, but they're actually extremely difficult to administer and the most expensive way to manage an estate.
Right. I mean, that's a number one reason to have a will, is if there are potentially minor beneficiaries or a beneficiary with special needs, somebody with disabilities, particularly mental disabilities that would prevent them from managing property or assets themselves, then the trustee is not subject to near the complexities of reporting or the expenses or anything that are involved in a court administered guardianship.
So,
And
so
the difference can be tens of thousands of dollars in expenses over the course of a beneficiary's life until they turn
in
18.
with a when you have a will, does is probate at your passing? How difficult and how expensive can probate be?
Well, it just depends on the estate, the nature of the assets, and how you say, and the beneficiaries and how well they get along. You know, assuming you've got a family that gets along fairly well, if you have a well drafted will, the assets are not horribly complicated, then probate of the will can be a pretty simple matter, not that expensive, and certainly not, it wouldn't take a whole lot of time to resolve the estate. You know, the flip side of that is you have uh, beneficiaries who are fighting over light bulbs and silverware and want to
It's
contest who's going to be the executor. And it's a very complicated estate with property all over in different states, and you end up having to go to several different states to probate, and that can be much more expensive and complicated. And in that instance, probably a living trust would have been a better option to deal with the situation.
as we kind of you've mentioned a living trust, and that is one of the other items that you could do in a good estate plan. What would be the primary way reasons why a person would prefer to have a living trust rather than just go through probate with a simple will?
Well, it used to be that one of the primary reasons was to secure privacy of the provisions and what assets are in the estate. It used to be, and I can't tell you how long ago it was, but at least probably 10 or 15 years ago, the Texas legislature enacted a provision where The inventory and appraisement of the estate, which lists and values all the assets, no longer has to be filed of record at the courthouse. And so that part now can be kept private without having a trust, although the terms of the will still be public record because the will has to be filed with the court before you can probate. For instance, if you had a beneficiary who had a drug abuse problem and you wanted to include provisions that the beneficiary had to remain drug free and be drug tested periodically, and you didn't want that to be a public record, then a trust would be a good way to do that. Then nobody would have any reason to know about that. Or if you have a very large estate and you don't want people coming out of the woodwork trying to, list property for you or handle estate sales or whatever. I mean, it's just crazy. As soon as the will's filed for probate, they start coming out. But the other prime reason to have one is it owning property in several different states, because of the fact that you may have to do what's called an ancillary probate in each other state besides the state in which you reside to take care of the transfer of that property. And if you put the property in a trust, you can avoid that requirement. So or if you have a beneficiary with special needs, it's a good situation to set up a trust to protect their benefits so that they don't lose what government aid they would receive by receiving inheritance, and yet it's still there to supplement their needs to a certain extent. That's be called a special needs trust.
And speaking from family history, we've had ancillary probates in New Mexico and Oklahoma in the family. So we've kind of had some difficulty there. Let's go ahead and take our first break. I do want to give everybody an opportunity that would like to visit with you about estate planning to get in touch. How would they get a hold of you, and where are you located?
I'm in the Amarillo building, the old historic Amarillo building at the corner of 3rd and Polk. My office is right next door to yours, Suite 422. We have a very friendly working relationship, but we also have a locked door between our offices, and we maintain our client privacy unless they give us permission to share. But the number you call me is 806-220-0150, or email me at Adair, Adair, at adairbuckner.com.
And if you'd like to get a hold of a certified financial planner at Dale Buckner Inc., you would only have to call us at 806-358-7977, 1-800-299-PLAN if you want to call us toll free. My email is dale@dalebuckner.com. We're also located at 301 South Polk, Suite 420. This is Dale Buckner's Financial Clinic, visiting with Adair Buckner. And Adair is an attorney and working in estate planning. And we were kind of talking about that basic will and powers of attorney package. And that is always kind of an interesting part where you start talking of powers of attorney. And I've kind of run into this often where we've had problems with one of our clients that may be losing capacity to make good decisions, sometimes it happens quite suddenly where a person is now in the hospital and on a ventilator. This is something that's really given us a whole lot of trouble here in the last year with the illnesses that are happening around COVID. And everyone should have a power of attorney directing the person that they trust the most to handle their business affairs. I kind of want to turn it over to Adair and really let her flesh that out.
It's one of again, a sad situation where you end up having to create a court administered guardianship, is where a person has failed to draw up a statutory durable power of attorney, is what they're called, to handle your business affairs, banking, real estate, you name it, anything having to do with your general business affairs. So that if you become incompetent or incapacitated and not able to take care of those things yourself, then there's no other option if you don't have a spouse. Now, if you have a spouse in Texas, it's assumed your spouse can handle those things for you. But if there is no spouse, and We see this all the time with elderly clients that, it's a widow or a widower and their children live far off. Then the court's going to have to find somebody to appoint as a guardian to handle the affairs. And there you go again on large amounts of attorney's fees and hassle and court time and a lot of complexities that would absolutely not be necessary if a person had just taken a little bit of time that's involved in drawing up a power of attorney.
I always wish to also recommend that we have other than just one power of attorney person. You have other people that might be able to step in should that power of attorney decide they don't want to do it, because occasionally they may be ill or have problems. You've set some things up, or a person can set things up that may not be appropriate for some time in the future. So having more than one power of attorney in order, an agent.
Agents, they're called.
Okay, thanks.
Right. Yeah, absolutely. Or they may have died. I mean, we see that people who bring in powers of attorney, they drew up 25, 30 years ago. And even if they named one or two people, one person and an alternate, both of those people may either be deceased or incompetent themselves. And then you're left with the situation of having to require a guardianship again.
Can you name something at the end of that and let somebody else choose another power of attorney, or is it pretty much?
You can provide in the power of attorney that, I mean, again, the person's got to be competent at the time. The person you named as the agent has to be competent to do it, but you can say, I allow my agent the power to designate someone else to act on their behalf under this power of attorney. Then you better make darn sure you trust the person. And I frequently have, and I know you do too, the clients that come in and say, well, I want my son or my daughter to do, but I want their spouse within 10 miles of my stuff, because I know what they'll do. And that could well be what happens if you leave them that freedom. So it's something you have to give some thought to.
Occasionally when we're starting to talk about this, we may be naming that alternate agent as a person that may even be younger than somebody that you would normally name. But I have clients now that are in their 90s, approaching 100. So as we go through this process of talking about naming folks, that you may be naming a grandchild that is just in their 20s, that eventually may be in their 40s when they become that power of attorney. It's kind of interesting to think about. But
or even people that are in their 40s now that have children that are in their early 20s, they may think, well, they're not old enough now, don't have enough experience that I'm real confident about it. And they say, well, now it may be that they're not going to be called upon to act for another 15 or 20 years. And by then it might be a whole different situation. Of course, you can always, amend or redo your power of attorney, but it's that like every piece of the estate planning package should be reviewed probably at least every 5 years, or anytime there's a change in your family situation, a new marriage, a death, a birth, any of those kind of family occurrences.
If a person were wanting to get in touch with you, is it a simple process, and how would they get in touch if they wish to have strictly a power of attorney put together so that they could properly handle their affairs?
It'll just be simple matter of giving me a call at 806-220-0150 or emailing me at adair@adairbuckner.com, or go to my website. Just Google Adair Buckner, and I've got on my website number of places where you can click the tab and contact me to set up a free initial consultation, just to talk about what you might need. And then we go from there to set up actually drawing up whatever documents you need.
And if you'd like to visit with a certified financial planner at Dale Buckner, give us a call at 806-358-7977, 1-800-299-PLAN. You can email me at dale@dalebuckner.com. You can Google Dale Buckner also, and my website comes up. And if you would like to, you can look up Dale Buckner Inc. It's I'm wearing a tie in that one. I'm wearing in on Facebook. You can actually Google Dale Buckner Inc. and get me with a tie on, and then that would be another way to get in touch. This is Dale Buckner's Financial Clinic, visiting with Adair Buckner attorney. And yes, we are married, and I'm so glad to have you on the show. And one of
My
the
pleasure.
areas that we talked about were powers of attorney, but there's another completely different type of medical power of attorney, and directive to physicians is a different document that are quite complicated for a whole lot of folks that also need to be. I've so many medical things coming up here recently, Adair, as you can
Yeah. With the
happen in
COVID,
our own
yeah.
family and everything else, that the medical powers of attorney, directive to physicians, have become remarkably more important. Can tell us a little bit about what those two and how they differ and how they're similar.
Well, what our office generally combines a medical power of attorney, directive to physicians, and a HIPAA release all in one instrument so that they're all there together and kind of operate hand in hand. But the medical power of attorney is broad, fairly broad, so that the person that you appoint as your agent under the medical power of attorney has the power to make any medical decisions for you, to secure medical treatment for you, to secure medication, prescriptions, whatever on your behalf if you're not able to. The living will or directive to physicians specifically sets out what your desires are for that agent to act on under the medical power of attorney if needed, and instructs the doctors or hospital, whoever, what your wishes are about any kind of extraordinary measures for maintaining you if you get in a situation where you are not believe that you're going to live for more than 6 months, or that you would only be in an irreversible condition. And and these also operate with a DNR, do not resuscitate, which is out of hospital generally, that takes effect. But especially with the COVID complications involving difficulty breathing, it's really important that you've expressed whether you do or do not want to be put on a ventilator at that point. Some people have really strong feelings about not being put on a ventilator because they think that that's kind of like a signal of the end. But artificial nutrition, any number of things are dealt with under the power of attorney. And I've had clients have very strong feelings on both sides of the issue. Some say, I want to be kept alive as long as possible and do anything. It's up to the Lord to decide when I need to go. And other people say, if I'm in that spot, the Lord's already decided I need to go. I don't want to be kept alive by machines. So it's a very personal thing, but it's really important that you've expressed your feelings so that your agent and the doctors and personnel know what your feelings are if you end up in that position.
And when if you don't have this with you when you go to the hospital, can that be a problem?
Well, yeah, I mean, somebody's going to need to secure it pretty quickly if it's an emergency situation, and the personnel need to know what your wishes are in that regard. So, if generally, if it's an elective kind of a thing, or you're going to the hospital, you can make provisions to get that to them. But otherwise, if it's an emergency situation, you make sure somebody in your family knows where those things are so they can be located quickly and provided to the
Can it be a
hospital.
copy? Can you have a copy of it,
Yeah,
or
yeah. I
so it
mean,
doesn't have to be the original?
no,
So
it's
you could
just
make 10
whatever,
copies and give it to everybody,
as
or
long
so.
as the people you're dealing with accept that. And I haven't run into anybody in my experience that wouldn't. Now, that's not true of some of the other things, like a statutory power of attorney. A lot of times, the third parties you're dealing with will require an original or a certified copy or something like that. But
We're running into some situations now where they want to have a fresh one.
yeah, and that really that really ticks me off because there's no statutory basis for that. They call them stale powers of attorney, And I mean, for a lot of people, it's a once and done thing. They're not reviewing their plans frequently
They don't
like
need to. They
they might.
already,
Yeah, but I mean, the fact that you've expressed your desires at one point in time should still be binding unless you've revoked it or there's some reason to think there was undue influence involved or incompetence. So that's kind of a tricky thing.
if you have big changes in your power of attorney or your directive to physicians or your medical powers of attorney, HIPAA releases, how would they get in touch with you to be able to make those changes? Is it a difficult problem to, let's say they've worked with you in the past or maybe worked with another attorney and they want them reviewed? How would they do that?
Oh, just a simple matter of giving me a call at 806-220-0150 or email me at adair@adairbuckner.com and we can quickly review. And in most instances on those things, since they're fairly simple and not all that terribly lengthy, it's better to just do a new instrument rather than try to add a codicil or amendment or something. But on a will, it's a little different. If it's a small change, you may do a codicil or an amendment and not have to completely redo the document. But the real caveat there is that the amendment or codicil has to be done with the same formalities as the original will, or it's not effective, which means it needs to be witnessed by two independent witnesses and notarized, and it all has to be done in each other's presence for it to be self-proving. And some people think, oh, well, I can just, mark through this and initial it on my will, or I can just add a page at the back of it and that's all I have to do. And that's not true. Unfortunately, you created a bigger mess probably than what you had to start with.
If you'd like to visit with a certified financial planner practitioner at Dale Buckner Inc., give us a call at 806 358 7977, 1 800 299 PLAN. This is Dale Buckner's Financial Clinic. My name's Dale Buckner. I'm visiting with Adair Buckner, attorney. And Adair, where are you located?
I'm in the historic, beautiful Amarillo building at the corner of 3rd and Polk and Suite 422. And we love it here. We love the view. We can look out the window and see the blue northers come in. It's a great, great location.
And as we kind of talk about this, one of the biggest problems that we've kind of run across is I'm going to say, virtually everything is when we have minor children that are beneficiaries of IRAs, minor children that are beneficiaries of life insurance, minor children that are beneficiaries of an estate, or especially the intestate beneficiary where both parents have passed away and there is no will at all. So as I kind of go through this process, if you have any minor children, you really need to have a good, solid estate plan in place. To the effect that what we say is that the minute you leave the maternity ward, you should go right down and get all your estate planning in order, or before you go to the maternity ward would even be better, but get all that in order. So how strongly do you feel about this, Adair?
That's a big part of my soapbox. And again, it goes back to one of the earliest examples in my law practice where I had a young couple that both had just started their medical practices and they had, I believe it's like a 4-year-old and a 2-year-old. The parents were both killed in a real tragic car accident, and they had a couple $1 million in life insurance to try to take care of their medical school debt and starting their practices, and then quite a bit left over. And they had no wills, no trusts, no kind of planning whatsoever. Nobody other than each other designated on the life insurance. So we started off on a path that went on for years of the grandparents fighting each other for custody or guardianship of the person, which is the actual physical custody of the children, and guardianship of the estates, which would be like the same as a trustee who would manage the assets. And it just ripped the families apart. They hated each other after that, destroyed the family relationships for the children. It was just a horrible, horrible situation.
I kind of go back into the same thing where we've done where there was not a contingent beneficiary named anywhere in anything, and you end up with something going in testate. Kind of explain what intestate means.
Well, that means that you don't have a provision for probate that the court would recognize. So then how an asset passes is determined by the statutory laws of heirship of the state. And that may not be at all how you want things to pass. A prime example of that is where a couple is, say, in a second or third marriage and have children by prior marriage. The children by the prior marriage will receive the parent who dies share of any community property, their one half of any community property, as opposed to that going to a surviving spouse.
So explain that, how that works. We have a couple that is they had prior marriages. They both all have children. We may have children from multiple prior marriages, and then all of a sudden we have an intestate community property house where they paid exactly the same amount to buy this house. They've been living in this house that's completely paid for, and then the surviving spouse is owning it with other children from the prior marriage.
That's right.
Oh, how much fun! What could go wrong there, Adair?
Yeah,
I mean,
yeah.
when you
Then,
sort of dive into
then
that.
you said, does the surviving spouse have to pay rent to the kids from the prior marriage, and who pays the taxes and who pays the upkeep? And
I want my money now.
Yeah, if they can't agree on things, can there be a forced sale? And the answer to that's no. There are provisions in the probate code for a homestead exemption or allowance for the surviving spouse, but still, I mean, it's just a really horrible, ugly situation, and probably not at all what the couple intended. And lots of times we've had situations where you can't even find those kids by, say, a first marriage where the couple got married right out of high school. They were married for 2 or 3 years, completely lost touch with each other, lost touch with the kids, and it just ends up being a royal mess.
Let's go ahead and take our last break of the hour. This is Dale Buckner's Financial Clinic, visiting with Adair Buckner, attorney. This is Dale Buckner's Financial Clinic, visiting with Adair Buckner. Adair is an attorney located at 301 South Polk, Suite 422. I'm a certified financial planner located at 301 South Polk, Suite 420. We are next door to each other. We do have a locked door between us, and we only share information when we're given permission by clients. Just a little bit of housekeeping here.
Yes.
And as we start kind of going through, a lot of our practices overlap in that we both advise folks to get an estate plan. We both are trained in estate planning. There's a completely different skill set when you start drawing up the documents as an attorney would do than the knowledge that a certified financial planner practitioner had, or any other financial planner might have. And so as we kind of come back into the discussion of the basic will, powers of attorney, directive to physicians, medical powers of attorney, and HIPAA releases as the basic set, there's another document that is often used that is a trust, or a testamentary trust, that could also be a great planning tool. And I kind of wanted to spend at least a minute or two here where we're talking about trusts, testamentary trusts, and other types of trusts. We can do a whole program on trust someday. Believe me, there's a whole other program we may do on trust in the future. But right now we're just talking about the living trust and the testamentary trust.
Right. Well, and another one of my soapboxes is in years past, there what I call traveling salesmen would come through town that had questionable qualifications, in my opinion, to be doing this. But they, have this big seminar where they treat people to a big steak dinner and sell them on the need for this huge living trust package that they spent $10,000 on, when the only assets they owned could easily have been passed under a will for, the price of a $500 will and a and a $500 or $750 probate, is just ridiculous. So, what's the best way to go depends completely on what your circumstances are. And you really need somebody that's competent and has experience in this area to advise you what you need. And, in some instances, a living trust is absolutely the best way to go, and the money you spend on it is worth every penny and will save you money in the long run. In other instances, you're just wasting your money to do it because there's no need for it, because in Texas, at least, probate does not have to be that expensive. Most attorneys I know don't work on a percentage fee. I just talked to an attorney this morning in Ohio who wanted to know what percentage I take of the estate. I was going, no, I don't do that. And I don't think most attorneys in Texas do, but apparently other places they do. But anyway, most instances of probate is not going to run more than $1,500, $2,000 for a fairly simple estate, and can be wrapped up in a couple of months. And if there are needs for testamentary trusts, which are the trusts that come into effect on your death, then those are easily set up under the will and just like spring into action, so to speak. And hopefully you've appointed somebody that's got a brain in their head to manage assets for the minor, or not necessarily minors, but even anybody that's not competent in your opinion to manage the assets yet, and they may be 50. So each has its place, but they definitely should be considered if there's a minor or anybody involved in your estate as a potential beneficiary that you have concern about their ability to handle and manage the assets if something happened to you.
The testamentary trust can certainly be used for that. We've got about a minute and a half left, Adair. Is there any word of wisdom that you could partake that would maybe get people? There's still that statistic that just bugs me. 80% of all adults in the state of Texas haven't got a will package put together yet. So as we kind of go through this whole process, anything that you could say in the next minute and a half that would change their mind?
It won't take that long. We just say, just do it. I mean, or do you want to waste money? Do you want to cause your heirs or your beneficiaries more trouble and heartache and expense by just not owning up to the fact that we're all going to die someday, and COVID has really convinced people a lot more of their mortality at a younger age than used to be true. But there's this bigger a need for estate planning for people when they're in their middle ages, and particularly if they have minor children, than there is for people in their 80s or 90s. So it's something that you need to just get off the couch and pick up the phone and call an attorney and get it done. And
it's real easy to get in touch with Adair. If you'd like to give her a call, come by her office. I know it's better to call now with the COVID thing. It's better to call and make an appointment. How would they get in touch if they wanted to visit with you?
Just give my office a call at 806-220-0150, or email me at adair@adairbuckner.com, or Google Adair Buckner and hit one of those consultation buttons on my website. There are a whole bunch of them. And I have a lot of explanations on my website about estate planning and probate, so you can read all about it.
If you'd like to give us a call and talk to a certified financial planner practitioner, it's free without measure. Complimentary consultations, 806-358-7977, 1-800-299-PLAN. Email me at dale@dalebuckner.com, and you can Google Dale Buckner, and I'm coming up right now.